Welcome to our webinar. I hope we will have a interesting and interactive discussion today with our distinguished panelists, who I will introduce in a moment. And for the audience, I encourage you to submit questions through the Q&A. We are here for you. We're hoping this is an opportunity to answer some of your most burning questions about False Claims Act enforcement going forward. So let me, without further ado, introduce the panel and kick it off. We have Ed Crooke. He's an assistant director at the commercial litigation branch at the U.S. Department of Justice. Owen Foster, assistant U.S. attorney from the U.S. Attorney's Office in the District of Vermont. Charlene Keller Fullmer, deputy chief of affirmative litigation, U.S. Attorney's Office in the Eastern District of Pennsylvania in Philadelphia. Abe George, who is the chief of affirmative civil enforcement at the U.S. Attorney's Office in the District of Massachusetts. Greg Shapiro, partner in Newman and Shapiro, and most recently, the former chief of affirmative civil litigation in the District of Massachusetts. And Rachel Burke, principal with Charles River Associates, an expert on compliance and complying with the False Claims Act. And I am Kirsten Mayer. I'm a partner at Ropes & Gray and your moderator today. So without further ado, we're going to kick it off with some sector-specific risk discussion. In the first instance, we're going to start with the life sciences sector, pharma and med device in particular. One of the big statutes that has been enforced through the False Claims Act over the years is the Food, Drug, and Cosmetic Act. In the past year, we've seen some significant enforcement activity under the Food, Drug, and Cosmetic Act and using the False Claims Act. Ed, would you like to tell us a little bit about some of the recent resolutions and where you see enforcement going under the Food, Drug, and Cosmetic Act with the False Claims Act going forward?
Yeah. I mean, there's considerable overlap in cases between the Food, Drug, and Cosmetic Act enforcement, which is through the commercial litigation branch, and the False Claims Act enforcement, which is through the civil fraud section and the U.S. Attorney's offices. I think probably a good example to start with, highlights a lot of different issues, is the Indivior resolution. Indivior manufactures the opioid treatment drug Suboxone. It is an opioid that is used to treat opioid withdrawal symptoms in opioid addicted patients. In that case, we investigated. There were 6 different qui tams that were filed against the company, and there was also a parallel criminal investigation. And in fact, there was also a parallel FTC investigation of the company that were resolved. We initially resolved with Reckitt Benckiser, the parent corporation, for $1.4 billion, and then later resolved with Indivior for $600 million. And the allegations there on the civil side focused on 3 different areas. The first one was allegations that the company had marketed their product to physicians that they knew were overprescribing the drug and prescribing it for uses that weren't medically necessary, and in some cases were being diverted, and in some cases were directing patients to those physicians, specifically directing the patients to those physicians through a program that was referred to as Here to Help. The second allegation focused on marketing the drug, one formulation of Suboxone, as being less subject to diversion and abuse than other formulations of the drug, and also less subject to inadvertent pediatric exposure than other versions of the drug. So there were false marketing claims were part of the allegations. And then the final area was an allegation that the company had filed a petition with the FDA to withdraw its tablet formulation from the market, and allegedly made misrepresentations to the FDA that the reason that they had filed that petition was to because of concerns about inadvertent pediatric exposure and patient safety, when in fact the allegation was that in fact they were intending to delay generic entry of tablets, and they took other steps, allegedly took other steps to delay generic entry, resulting in increased prices paid by federal healthcare programs. So those were the allegations that were resolved on the civil side, and it highlights the range and also highlights the department's ongoing priority of enforcement in the area of opioids across the board, not limited to obviously the life sciences area, but also in other areas. And I think we'll be touching on some of those later in the panel. The case also highlights our ongoing interest in ensuring individual responsibility. As I mentioned, there was a parallel criminal investigation. There was a criminal resolution with Indivior Solutions, which was a subsidiary of Indivior. And then a criminal resolution with two executives of the company, including the former CEO of the company. The CEO pled guilty and was ultimately sentenced to 6 months in prison for the specific charge that he pled guilty to was misdemeanor misrepresentations to the Massachusetts Medicaid office regarding data related to inadvertent pediatric exposure. But at the sentencing hearing, there was other information that was provided to the court, and I think it reflects, the government's ongoing interest in ensuring individual responsibility. So, I think that's a good example. Obviously, another large area in the life sciences, that's also in the opioid area, and is the recent resolution with Purdue Pharma. We have other experts on the panel that can address that issue. I don't want to get too far into it, but I think that's another key area showing, again, interest in opioids and ongoing enforcement within the area of life sciences.
Can I say one thing about one aspect of Indivior toward the criminal piece that Ed mentioned is, I think, interesting in a lot of ways, not just because of that there was a charge against an individual, but for what it involved, which was misleading a health plan. In that instance, it was Mass Health. But this isn't the first time that there's been a case against a pharmaceutical company where they were either making misrepresentations to a health system, or were paying kickbacks to individuals who worked on a pharmacy and therapeutics committee, or somehow had influence over what drugs that health plan would favor on its formulary. The state of Texas brought a case against AstraZeneca a few years ago. And I think this is increasingly a risk area for pharmaceutical companies as they focus their efforts on health plans. And health plans, especially big integrated health plans, have enormous influence on what drugs doctors are able to prescribe. And as a result, there's a huge temptation to either curry the favor of individuals at these health plans, or overall to give some sort of benefit to the health plan, for example, to curry favor with the health plan by offering clinical trial work or some other way to provide remuneration to the health plan, or to make false statements to the health plan. So I think that's, I expect that this will not be the last case where there's some impropriety involving the interactions between a pharmaceutical company and a big health plan, whether it's a private health plan or a public health plan like Mass Health.
Greg, do you think some of the increased risk in this area and the new types of conduct that you flagged you're seeing with life sciences companies' interactions with payers, is this being driven by changes in the way the payer industry is managing risk themselves, their payment risk and their beneficiary populations, or is it being driven by something else, do you think?
No, I think it's a slow change in the industry. Prior authorizations are more and more important. And so, and health plans have more and more control over, more and more doctors now work for large health plans. They're not as many independent private doctors in private practice anymore. And so as these health plans get larger and larger and more influential, there's the efforts of the pharmaceutical companies necessarily are going to shift from targeting marketing to individual doctors to marketing to health plans, and the risks will shift accordingly. You're on mute, Kirsten. You're on mute. Still on mute, but maybe we can.
While we're waiting for Kirsten, no, I agree with you, Greg. I think we're going to see more in that area as time goes on, as health plans do become larger and have a larger share of the marketplace. I think we'll see pharmaceutical companies directing their marketing efforts and focusing their marketing efforts on those the larger plans, and whether they're private or public plans. Even within public plans, we see Medicare Part C expanding, and the plans having more control over a larger swath of Medicare beneficiaries. And so I think we can expect to see more activity in that area. I'm hoping that it's not fraudulent activity, but I think we'll be seeing more activity in that area.
Thanks, and I apologize. I had some technical difficulties there. Thanks for continuing the discussion. We got a question in Q&A, and anyone can take this. And the question is really, would payer guidance from the FDA provide some degree of protection or full protection for the kind of communications that we're talking about and that was at issue in the Indivior case?
The Indivior case was focused on misrepresentations, false statements that were made, allegations of false statements that were made to the FDA, false statements that were made to physicians and to other healthcare providers who were prescribing the drugs. And I don't know that payer guidance from the FDA would provide protection in that circumstance. But
I think the most important lessons are the standard ones. Tell the truth. Don't lie to the P&T committee, and don't give kickbacks to members of the P&T committee. Don't give kickbacks to the entire hospital system or to the health system in an effort to get your drug better formulary placement, or to get a better contract or better pricing with the health system.
As a general matter, if the FDA has provided, for example, guidance that suggests that if you've checked certain boxes in your communications, that from their perspective that will be sufficient, does DOJ generally, again, without passing on a specific set of facts, does DOJ generally recognize that if the FDA's issued guidance and a company complies with that guidance, that would not be a case that DOJ would typically want to pursue?
I think the way that you phrased that, Kirsten, suggests the answer. I don't know whether I want to weigh in on this before having a specific case in front of us.
Fair enough. Fair enough. And as follow-up to the question, I'm just looking at the Q&A sections. How does the increased risk is there increased risk to payers as well from this kind of conduct?
Yeah, I mean, like I said, the conduct is focused on the entity that was making the false statements. I mean, in this case, the payor, the Massachusetts Medicaid agency didn't have the information they needed to make an informed decision regarding what was going to be on the formulary. So we weren't looking at payors and whether the payors faced risk in that circumstance. The payors were the ones that were duped and or allegedly duped. And so we were focused on the entity that was making the false statements, and their false statements were focused on the payors.
I think there's potential risk for individuals at health plans and payers, where especially if they're soliciting kickbacks. It's unlikely that the payers are going to be involved in making false statements. They're probably going to be the victims in a false statement case, but there's a temptation to take money or take fancy dinners or something in exchange for somehow favoring the pharmaceutical company or medical device company's product.
One of the areas that was part of the Indivior settlement, you mentioned it, Ed, that intersects with another risk area in the life sciences industry is drug pricing. You mentioned that one of the third piece of the conduct, the covered conduct in the civil settlement agreement involved allegations around discussions with FDA that was designed allegedly to delay generic entry. Greg, Ed, Owen, Abe, really anyone, is this conduct that you see on the increase, or was this a little bit of a unicorn just given the circumstances of this particular case?
I'll defer to others, but this is the efforts to delay generic entry. I think I think all that is not new, and I think it's branded drug companies have a strong financial interest in delaying the entry of generics, and they have a number of tools at their disposal to do that. Our concern wasn't specifically in the fact that there was a delay in generic entry, but the manner in which it was accomplished. There were false representations that were made to the FDA about the reasoning and the rationale for filing the citizen petition. It was the focus of the separate parallel FTC investigation of Indivior. I don't have sort of broader information about whether there's an increase or decrease in efforts made to delay the entry of generics and extend exclusivity. But as we see cases where those efforts veer into false statements or fraud, we'll continue to investigate them.
And one thing I noticed just towards the end of my career at DOJ is that there was increased coordination between the fraud attorneys and civil frauds in the U.S. Attorney's offices and the antitrust division. Whereas I think for the first probably 14 years of my career, there was no interaction between those two parts of DOJ. During the last few years, there's been a lot more, and there's been a lot more focus on whether antitrust violations can cause False Claims Act violations.
Yeah, and from an FCA perspective, if the delay is the result of some sort of fraud or a patent that's invalid or something like that, that's something we would definitely look at.
We've touched on kickbacks, and I want to turn, hold on a second, before we do that, we got another question in. We have a question around kickbacks, so this is great. We're going to go ahead and turn to kickbacks right now. And I'm going to turn to you, Charlene, and invite you to weigh in. One of the significant settlements of 2020 was a settlement with a pharmaceutical company around speaker programs. Speaker programs were a risk. We saw a bunch of enforcement activity around them a decade ago, and then it felt like all the big cases focused on other things, and speaker programs have kind of come roaring back. Would love to get your thoughts on whether, again, this is really just about cleaning up conduct that's now decades old, or whether this is sort of a new and emerging risk. And in connection with that, we all noted that OIG put out a special fraud alert in November talking about speaker programs, and they don't issue special fraud alerts that often. So be interested to know whether you see speaker programs and those kind of relationships with healthcare providers as an sort of emerging, the emerging old risk, but new risk.
So great question from the audience. How long has the history of kickbacks happened? Okay, well, as long as there's an incentive for people to make money, right? As long as there's an incentive, unfortunately, that we see in the industry for there to be remuneration in some form. And if, let's understand why these anti-kickback statutes and related provisions are in place, and it's to protect the patient. It's to protect consumers and patients from the illegal influence of doctors on and on prescribing or taking appropriate action because that doctor is influenced in any way by a particular manufacturer through this remuneration, which obviously jeopardizes the risk of patient harm. And so, to answer your question, Kirsten, I mean, looking back in the large settlements in the department in the years that many of us on this call started practicing, so let's say 15, 20 years ago within the department, the off-label cases that resolved in the billions of dollars were focused not so much on the kickback behavior between manufacturers and doctors, but rather on the submission of false claims related to off-label marketing and promotion by manufacturers. Although Greg handled the kickback side of a pharmacy related to a very large resolution, the Risperdal case. But the focus was really on the claims submitted and the conduct of the pharmaceutical manufacturers in the promotion and in the sales of the products. We released, as a matter of course, kickback allegations that were related or alleged in those complaints. But I would say that after the big wave of off-label matters resolved in the billions of dollars, we started to see either through declined quitams that were still being litigated by Relators Counsel or in additional investigations, a lot of son of drugs or successor drugs coming into the market involving same manufacturers, that there was a large focus on speaker programs and whining and dining, and the offering of remuneration to those physicians for the referral and the prescription of drugs related to that manufacturer. So you've got, a number of the largest settlement in the last few years has been Novartis for $678 million out of New York for speaker programs. We've had a series of smaller settlements here in EDPA. We had Abbott speaker programs, $25 million a few years ago, QuestCore, $15 million also a couple years ago. And you're seeing these cases being brought also and being pled in QTAM complaints along with open payment violations, which is interesting. So, after the Affordable Care Act was enacted, the idea that there should be transparency, and I think, certainly a credit to the department and many individuals on this panel, that as a result of these large settlements, what are doctors and manufacturers doing, and what remuneration is being received? And again, consumers and patients have a right to know what that is. So with the required reporting of remuneration that was received by these individuals, it's another tool for the department to use in conjunction with CMS to see what's actually happening here. And so in the last year or so, we've announced a number of AKS resolutions in conjunction with open payments as well. In fact, $9 million last year, a very large case coming out of South Dakota with a physician who had created two companies and spinal manufacturing companies, and he was a surgeon. And he and Medtronic had a very nice relationship. And so Medtronic would offer speaker programs and pay this doctor to have the programs be held at his restaurant that he owned, and also promoting this doctor's products. And, to the tune of something like 130 events, over a 9-year period of time. And the remuneration paid to this particular physician, not that great, but the idea that, there is going to be, a blatant promotion without medical education or medical content where there's drug and alcohol and spouse is invited. Those are things that the department is going to pay attention to. And so we're talking about, in that particular case, an $8.1 million resolution on False Claims Act piece related to the AKS, but also a $1.1 million open payments resolution. And the open payments statute is a penalty statute, so the numbers end up being smaller. So it's $150,000 per violation, up to a maximum of $1 million a year for a particular company. So those end up being smaller. But shortly following suit after that, it was just recently resolved, actually a couple weeks ago rather, the doctor himself ended up paying $4.4 million on sort of the flip side of that kickback. So you're seeing not only a focus on the manufacturers who are engaging in the conduct, but also the physician and holding that physician individually accountable. Today, actually, out of our office, we just announced at noon today a resolution with Medicare, corporation, a French company who flew surgeons and their families out to France for a presentation and wined and dined and paid remuneration in the form of essentially vacations for these families, so as to promote its spinal products for use in surgeries. And as a result of that 2 million, again, 1 million AKS, 1 million for open payments. So I think you're going to be seeing a lot more of these. They tend to be smaller dollar matters, but the issues and the themes still resonate years later. And the department's committed to looking at these kickbacks in whatever way, shape, or form. And if it means smaller dollars, so be it. The idea that the conduct needs to be deterred is something that is important to the department in terms of its mission.
And Abe's had a bunch of settlements with doctors in a spine case, and you can talk about that. But it's clearly, they're not huge settlements, but for the individual doctors, it's a decent amount of money, and hopefully it's a real deterrent.
Yeah, we have an open case litigated now against a spine company. It's a somewhat similar situation to the case that Charlene was talking about. But in addition, we've already announced settlements with I think 6 physicians who were the doctors who received kickbacks in the form of sham consulting with respect to that company that we're litigating against.
So consulting programs, speaker programs, concern about bribery, as Charlene mentioned, is something that goes back many, many decades. One of the things that is new coming out of the special fraud alert is that we're all coming out of 18 months of home confinement, so to speak, where consulting programs and speaker programs have been remote, if they've been held at all. And I'm interested in, Greg, Charlene, Abe, Owen, Ed, any of your thoughts on whether you think that we should all expect speaker programs, consulting programs to come back live and no longer be remote once restrictions are lifted, hopefully.
Well, I know what Greg Shapiro's position is on this, but something I do want to mention, I think it's important, I forgot to share, is that HHS's increased review and influence in this area is important in terms of the corporate integrity agreements that are being entered into as a result of these settlements, where HHS is dictating specifically to the manufacturers and to the doctors, in addition to, by the way, the physicians being excluded for 5 to 6 years as a result of the conduct. But specific language in the CIA that you shall not have speaker programs or programs of any type where alcohol is served. They have to be in a classroom environment, right? So I wouldn't be surprised if there are specific mandates coming forward as a result of violations by either the manufacturers or the doctors, that it be limited to certain formats like virtual formats.
Or classroom-like formats where doctors aren't going to want to go. But one other risk area that, in addition to meals and consulting fees, is royalty payments, especially by device companies. Some device companies pay enormous royalties to physicians And when the numbers get that high, I mean, certainly the defense is, well, the physician contributed in this really substantial way to the development of the device, but those numbers raise significant questions about whether at least one purpose of the payment is to convince the doctor either to use the device, or because the doctor is influential, to speak about the device, or to talk to his colleagues about the device, or to talk to his fellows about the device. And so those royalty payments have a huge potential for crossing the line into kickbacks, even if there may be a legitimate purpose, but there may also be an illegitimate purpose.
Well,
Right,
Greg,
and Greg, that's a great point, because in open payments there are the specific the payments are listed, and sometimes it would blow your mind to see some of these. $500,000, $250,000, right? So at first blush, we see this information. What do we do with it? And we can send civil investigative demands or subpoenas to request the basis for this this remuneration. And as Greg says, sometimes it looks legitimate, right? Licensing agreements or appropriate royalties pursuant to a contract, right? But if there are indicia of other relationships or other types of influence involved, it's one piece of what we will evaluate.
Like if there's an internal company email that talks about, well, we've got to get this doctor on our team for everything now, sure, you want to get them on your team to develop your products, but when you have emails like that, that suggests that you want that doctor to be using your product and to be proselytizing about how great your product is.
I want to push back a little bit on this, Greg, and let me put it this way. You teed up royalty payments. Royalty payments are for intellectual property, provided that that the physician qualifies as an inventor, and there are legal criteria that define that. And it's a market value payment in terms of the royalty. It's not enough.
But what's the market?
You're fine, even if one purpose of partnering with the doctor is to make a closer connection with the doctor and for the company, the one purpose test isn't a necessary and sufficient test for any kickback liability. A fair market value royalty payment for invention is fine.
I don't think anyone on our side agrees with you on that point.
No, so seriously, like show of hands here, because it is something I encounter in briefs and in litigation from time to time. Is it your view, and I'm not saying the Department of Justice's view, but just the group here, that if a financial arrangement's entered into with a customer, a doctor, and you're a life sciences company, and one purpose of it is to encourage prescribing your product, is that full stop enough for any kickback liability?
I think so.
Yeah.
Yes.
And
Yes.
so safe harbors, you don't qualify if one purpose is to encourage prescriptions.
I guess you'd have to take that case by case, but generally no.
Any different views, or are you guys all aligned on this?
Yeah, I think what maybe you're talking about, where we might meet in the middle a little bit, is on our discretion. There might be situations where if it otherwise makes sense and it doesn't appear to be that shady, perhaps it's not a case we'd bring. But I think we'd all be in agreement that if one purpose was to encourage prescriptions, that is a kickback. That meets the parameters of the anti-kickback statute.
Correct.
I won't get us bogged down here, but we can have a separate conversation offline about the role of the safe harbors. But
I think the point now is just that it's a danger area.
Huh?
It's a danger area that people who work in pharmaceutical companies and medical device companies have to be highly cognizant of when they're involved in negotiating these arrangements, because the sums are, as Charlene mentioned, the sums are enormous. You talked about fair market value, but when a jury hears that a doctor was paid $500,000 a year for for not that much work, it's going to be a tough road to hoe for a defense counsel.
I mean, these cases are particularly attractive in terms of an incentive for the department to move forward when you have, Abe raises a good point, right? Just because there's a strict violation and the one purpose test is met doesn't necessarily mean the department is going to be either intervening or filing a complaint intervention or bringing that case forward to litigation. Okay, we're looking at other indicia of evidence that is going to, inform us what was going on in the minds of the companies and of the doctors involved here. But I will tell you that, in negotiating these cases, even on the eve of trial and litigation, these cases have significant jury appeal, and juries understand this type of kickback, right? Okay, it might not be, handing an envelope over to, a doctor across the table in cash for, a patient referral, right? But they get the idea that a form of entertainment without any, legitimate medical education or purpose behind it, to educate or help, advance patient, understanding, knowledge, or, support of that industry can be tantamount to something that is going to influence that doctor to refer, and it's going to affect a patient. And so they get it. Like, when you're in an environment where the alcohol is served and nothing else is being discussed except, how great this drug is in general, or not even that, but without the appropriate, educational content, what else are we supposed to think about this? And so these tend to be very solid cases for the department to bring, especially when there is, in most cases, as Abe and Greg mentioned, emails and additional evidence and support and continual reward of physicians, even though there has been maybe in some instances patient harm or additional unnecessary medical procedures, right? So in the case that I mentioned earlier involving Dr. Sfora and Medtronic, I mean, he was using his device that he had created in his ancillary company, and recommending that those be used in unnecessary medical procedures. So, usually this is part of one, bigger issue that we see with respect to the parties at play here. But it tends to be a very a concept that juries understand and can get their head around, unlike, billing and drug pricing that can be more complex, especially, in the Part C area, where these are more complex, difficult cases to bring and to convey, a jury to find defendants liable.
I want to follow up with a question just quickly before I let you jump in, because the questions are starting to stack up, which I love. So keep them coming in the Q&A from the audience. I really appreciate it. And I wanted to sort of poll our panel here, sort of show of hands again. And this is to dig in a little bit on the special fraud alert. One question, we talked a little bit about live programs versus recorded programs, or programs in a classroom setting. Versus the more traditional setting for speaker programs, which might be a private room in a restaurant. How many people here at DOJ think, again, not speaking for the entire department, but would view live programs as sort of inherently suspect coming out of the pandemic as restrictions get lifted, or a program that's not in a classroom setting? Does anyone want to address?
Kirsten, I would say there's a lot of looking at what the doctor is doing. I mean, if you look at a compare and contrast between the work product versus the amount of effort they're putting in to market the product, that tells a pretty obvious story. I mean, the kickback statute is really an intent-based statute. So you can look at what they're actually trying to do versus what they contract for. And then, second, are they disclosing problems, or are they only boosting the product sales? So I think if there's kind of a spectrum of, balance of how much work is being done and how much, marketing is being done. We've all seen cases where you have 2 or 3 pages of work and then hours and hours and hours of effort to sell the product. And you see the decision-making to put them on a speaker program being tied to the, marketing work that they did, not, their legitimate work. So I think it's pretty easy to look at that and see what they're actually doing and spending their time on and what they're being rewarded for.
Yeah, and Kirsten, I'd like to go back to your earlier question where you asked us to raise our hands, which I don't like that format. I don't know about anybody else. I don't like to have to raise my hand for a particular question. But I will say on the earlier question of satisfying the safe harbor, You know, OIG has set up these safe harbors because they've identified certain areas that are less risk of improper influence, and so there's lesser concerns. And you know, I think what the panel is saying, or at least would be a consideration for me in an investigation, is did they actually satisfy the requirements of the safe harbor? And I have to say, a lot of times when defense counsel comes in and explains that they've satisfied the requirements of the safe harbor, they've satisfied them in spirit. That sort of, you know, we satisfied the gist of the safe harbor, or this, you know, seems to fall within the safe harbor. But when you drill down, they haven't satisfied the very specific requirements of the safe harbor. I think in a situation where a defendant had acted in good faith and taken steps to ensure that they had satisfied all of the requirements of the safe harbor, that's not a case we're taking. That's not a case we're pursuing. That's actually a case that we could probably shut down pretty early. But the issue is that when we dig in, we find that they haven't actually satisfied the requirements. They might have gotten a fair market value assessment, but then in the end, it was, you know, there's a lot of emails and communication where it's clear that it was either, you know, influenced or was an after the fact justification for something that was done, or the choice of the physician was because that physician was the one that was doing it, and it reflected the payment actually wasn't fair market value, it reflected the value of those services. You know, the personal services safe harbor, we were talking about the speaker engagements, and, you know, it's rare that I've seen a contract with a speaker that satisfied the specific requirements of the personal services safe harbor. So I think in the end, where we end up with these kickbacks is it ends up being a fact specific determination, you know, and you know, if the provider or the healthcare entity has actually satisfied the requirements of the safe harbor, it's, you know, there's plenty of other cases where they haven't, and that's where we're going to focus our attention. So, you know, I don't want to suggest that, you know, entities that are acting in good faith, you know, and complying with the requirements of the safe harbor, you know, face the risk that other providers who aren't satisfying those, you know, the requirements of the safe harbor, and are taking into account the value of the services, you know, that's an issue. So,
Kristen, there's a question that came in about HHS's, you know, prohibition of alcohol at speaker programs, and I just wanted to clarify that. So what I was referring to was in the Novartis settlement with the Justice Department, and again, it was a very large settlement over, you know, capturing a long period of covered conduct. So it was $678 million that was paid to resolve False Claims Act allegations and anti-kickback statute allegations. The HHS executed a corporate integrity agreement with the company as a result of that settlement, so that the company would not be excluded under federal programs, right? So it can waive its exclusion authority, and then requires these entities to enter into corporate integrity agreements for a certain period of time. One of the provisions in that Novartis specific corporate integrity agreement was that Novartis, in external speaker programs, those have to be conducted in a virtual format. Okay, so they can't organize gatherings outside of healthcare practitioner institutions or offices, and that Novartis may no longer host speaker programs in restaurant venues or provide alcohol. So that was specific to Novartis as a result of Novartis entering into the settlement agreement and the HHS requirement in the corporate integrity agreement, so that the company could continue doing business.
That's great. So one question that's come in is sort of, you know, a lot of freewheeling discussion about the risks in the area. You know, can companies analyze ROI if they do speaker programs? You know, is that something they really even can do from your perspective?
I think they can do ROI on the audience members. If the audience members didn't get anything, didn't get a fancy dinner, they just got a moderately priced meal and not much alcohol.
A soggy sandwich and a Diet Coke.
Right. But you know, certainly if there's ROI on the speaker, that's like red meat for us.
I actually don't think I've seen ROI in an email for the last 5 years. So,
but it was in. If you watch,
I think there's a ban on the
Century
use of that term.
If you watch,
so I mean, right? What is the intent behind the company tracking this? Why are they tracking their return on investment on a doctor that is, you know, receiving honoraria or any other type of remuneration, and taking a look at that particular physician's scripts over a certain period of time, you know? And then as Greg mentioned, you know, we obviously track that information and look to see whether, you know, what the reimbursement looks like and whether or not it increased or decreased according to how much honoraria was paid over a certain amount of time. I mean, why is the company doing this in the first instance? We're not, revenue is not wrong, right? That's the reason they're in business, but why are they particularly tracking this? And then in conjunction with other evidence or emails, it's compelling.
Yeah.
And I think there was a decision from Judge Woodlock several years ago in I think it was US Exoral Poker versus Pfizer. I think that's the right case. But anyways, where he said there was a discussion of ROI, and in that case, it was ROI on the program and on the audience members as opposed to on the speaker, and the court found that there wasn't a problem. And I think that DOJ typically would take the same approach as long as the audience members were not getting a kickback too. But the flip side is, if you watched Crime of the Century this week or last week and looked at the INSYS ROI analysis on the speakers, well, that's great evidence.
Yeah, I was going to say that the only place I've seen ROI recently is the INSYS trial, and everyone knows that case. But to go back to something you had asked Kirsten, excuse me, about the about live events. I don't want to speak for everyone on the panel. I don't think that we would inherently view a live event as a violation of the kickback statute. I don't think it's DOJ's place to say that you can have a live event or not a live event. OIG may say that if you've already got a problem, you know, in a CIA, but I don't think the Justice Department is really going to opine on that. What we're going to look at is all the things we've been talking about. What's the reason why you had this program? What's going on at this program? Are you actually teaching? Are you actually educating? Or is everyone that's just there to eat a really good meal? and that to try, what's the purpose of that? The companies aren't charities. Why are they hosting these events that are very expensive, if not to get a return? So if there's legitimate education going on, we're not going to be interested from an enforcement perspective. So live or not live.
So one of the things I want to turn to, and there are a couple questions that are coming in, and we'll try to turn to those in just a moment. And I want to talk about a slightly different form of kickback that we've seen significant enforcement activity around of late, both by DOJ in certain contexts and by whistleblowers in non-intervened contexts. And those are around patient support or product support programs like benefit investigations. It could even be nurse educators or reimbursement support, other types of reimbursement support, as well as patient copay programs or other patient assistance programs. Would love to get thoughts from the panel about what types of risks they see in that area for life sciences companies going forward. And if I may, if I could ask you also to comment if there are differences or different risks that rare disease companies face. I know, Greg, you have some thoughts about that around the patient assistance programs and the patient copay programs. And the questions come in from the audience around speaker programs and consulting programs in the rare disease space, where they're often, you get a situation where you have a fewer number of, it's a smaller disease space, so there's a smaller number of experts, and so the KOL community tends to be concentrated, and companies can find themselves in sort of potentially having to make judgment calls about some trade-offs that you see in tensions in the DOJ enforcement space, where on the one hand, DOJ doesn't like you to concentrate your KOLs into too few people, because then the amount of use and payments to individuals can climb. However, if you spread out your payments among a lot of speakers, which keeps the overall cap for the speaker individuals quite low, if you have a rare disease, you have a smaller population of doctors, and you can start running into enforcement risk there, that you're spreading things too broadly. So would be interested if you wouldn't mind just commenting on how some of these kickback issues play out for rare disease companies. If you see any difference for them, you may not.
So you said a lot of different things. Going back to the beginning, you were talking about reimbursement support, and I'm not aware of DOJ having brought a case based purely on reimbursement support. Although I think theoretically it could be a kickback in that you're providing a service and saving the physician time and money on hiring his or her own staff to deal with prior authorizations and things like that. But I think where those cases cross the line and where there's real danger is where the reimbursement support involves making misrepresentations, primarily involving prior authorizations, so which are a huge part of our healthcare system, and I don't think are going away anytime soon unless we get nationalized healthcare. So prior authorizations were a part of the INSIS case. They were part of the Warner-Chilcott case, but I think now more and more the fraud in prior authorizations is shifting from pharmaceutical companies to either their contractors or to pharmacies. So if hubs or specialty pharmacies are involved in the prior authorization process, there's a huge temptation for them to lie, to claim that they're working for the physician. And again, I'll refer back to Crime of the Century. There was a good recording of someone from INSIS claiming that they worked in the doctor's office. And unless you say you're working for the doctor, the PBM or the insurer is not going to listen to you when you're talking about a prior authorization. So you have to say you're working for the doctor, and then there's a huge temptation to lie about the patient's clinical history or about the drugs that they've tried and failed, or if it's in the DME space, whether the prior therapy that they've tried and failed. So to the extent that a pharmaceutical company is involved in any of that, even if indirectly, or if they're aware of it, and tolerate it because it benefits them, there's a potential liability for the pharmaceutical company. In terms of quickly on copays, and Charlene can talk more about this, but she had a recent case involving a rare disease company basically setting up their own copay fund. I think that's a continuing danger for rare disease companies because their drugs are so expensive and basically almost no one can afford the copays. So they've got to figure out some way for Medicare patients to cover those copays. And they increasingly commonly are setting up, working with a foundation and just setting up a fund that covers their drug. And I think that's a risk area that Charlene's recent case highlighted. And then in terms of the question about KOLs for rare disease companies, I don't have an easy answer to that. I think it's, you just gotta be, that's a real risk area and you gotta be very careful. If there's only 10 doctors in the country who use your drug and you start paying 8 of them, you got to be real careful about why you're doing it and what kind of records you create in terms of that may reflect why you're doing it.
Terrific. This has been a terrific discussion, and there are a couple questions that I want to loop back to a little bit later if folks can have some patience. But in the meantime, I want to turn to a different sector and bring Owen into the discussion for this to talk about EHR and digital health enforcement. This is an area where we've seen increased activity by the Department of Justice and some high-profile settlements in 2020 and 2021. Owen, have we seen the end of enforcement in the EHR space, or are we just getting going?
I would be surprised if we've seen the end of enforcement in the EMR space. I think the first, larger case against an EMR was 4 years ago this month. And since then, we've seen a proliferation of schemes and violations. We've seen the cases move into the criminal realm. We've seen additional USAOs start investigating these cases. Greg and his office did one this year. There's a standalone kickback case against Athena. We saw New Jersey do one. We saw Miami settle one a couple of weeks ago, I think, CareCloud. And we're seeing a lot of variation amongst the cases. And so in my estimation, I think we're really just scratching the surface. When these investigations have started, we really had no idea of all the various issues that we'd come across. So the first case was really about cheating certification and allegations of kickback violations and EMR performance issues. And then in the second case, we saw issues with manipulating data that was relied upon for physicians to receive money from CMS. And then in the third case, which was last January 2020, we started seeing a third variety of violation, and that is using the EMR to manipulate and influence prescribing. And what we saw there was really using workflows and alerts to suggest and influence doctors to take certain actions that were favorable to pharmaceutical companies making payments. And so the EMR is interesting because of all these different entities in the healthcare ecosystem. They all in some way touch an EMR. So you have physicians, you have pharmacies, you have pharmaceutical companies, you have laboratories, you have billing and practice management, you have data, you have PHI, you have all these various touch points all sort of going into an EMR with all sorts of opportunity to use technology to influence what happens. And going back to the kickback discussion, when the intent of the remuneration being given to an EMR or paid out by an EMR is to recommend or arrange or refer somebody for a healthcare service, you have kickback issues. And so I don't think that we are done with EMR cases. And I actually think that we're going to see a lot more variety going forward. And I think we're going to see more and more U.S. attorneys' offices, pursuing these cases.
And the Purdue case was particularly fascinating. I mean, I think it's all very interesting. No one's done fantastic work in this area, but the Purdue case where they found that Purdue was paying the EMR company ultimately to promote use of Purdue products is something that I don't think is unique to Purdue, and I think is a huge risk area for pharmaceutical companies if they are paying any money to an EMR company. Why are they paying that money? And how is that going to look down the line if the government investigates or if we have to present that to a jury? When doctors find out that their EMR is recommending things because of something that a pharmaceutical company paid for, they're going to be offended. They're going to be fantastic witnesses at trial. And the jury is going to be outraged that when the doctor is looking at the screen during their physical exam or during their exam, when they come in for some ailment, that something pops up on the screen that's paid for by a pharma company. That's terrible optics. And I think that those are going to be great cases if that practice continues.
Yeah, Ed made a comment that he hadn't seen the term ROI in emails in a while, and that just made me think he must not be reading my emails that I sent him. My cases are filled with references to ROI. And to Greg's point about not just being about Purdue, well, in the Practice Fusion case in the civil settlement, I think there was the release covered 10 additional pharmaceutical companies, I think 14 total CDSs. So it wasn't just Purdue. There were additional companies for which Practice Fusion resolved the case. The other point I'd make on this industry, and as it touches all these others, is that EMRs it's a youthful industry. They've sort of really sprung up out of the Affordable Care Act, or America Reinvestment Act. And so a lot of the companies have sort of seen themselves as tech oriented and not really appreciated or taken the measures that they need to ensure compliance with all of the regulations and rules that go and are involved with pharmaceuticals and billing and labs and everything else. So I think they're sort of ripe for abuse because not many of the EMRs to date have really had the kind of compliance programs you'd expect or the risk mitigation measures you see in more mature industries.
Oh, and one question that's a couple people have raised this in different ways in the chat. You mentioned that a risk area for pharmaceutical companies, and Greg reinforced this, is if their payments flowing from pharma companies to EMR to accomplish certain things, to have the EMR direct doctors to a particular product. Is that concern apply to like banner ads or advertisements for a product within EMR where it's clearly that it's an advertisement as opposed to the EMR sort of through some sort of ostensible practice guideline workflow or something like that? So really, it's really advertisements. Can companies essentially advertise in EMR?
I think they can. I think it depends on what and how they're advertising and what information they're using. I believe, if I remember correctly, there might even be a couple OIG AOs, alerts on advertising in EMRs or advertising. And I think those, if I remember correctly, talk about whether or not you're doing it at exactly the point of prescribing and whether or not you're using personal health information to do it. Recently, I think last week, the Massachusetts AG's office filed a lawsuit alleging that Publicis was working with Purdue Pharma and was using personal health information to trigger alerts at the point of prescribing. So a patient comes in, they see the doctor enters information about them, and boom, based on that information, an alert pops up. So I think it really depends on how the ads are structured. I mean, there are certainly ads that you can have in EMRs that are not violations of the kickback statute.
Yeah,
Fantastic. Yeah, go
I
ahead,
do
Ed.
want to emphasize, I mean, I don't think we can, emphasize this enough. I mean, EHR is the hub from which nearly every medical decision is being made at this point. It's a critical part of our healthcare infrastructure, and it's and it is a key priority for the department. The acting assistant attorney general, when he took his office, gave a speech and identified EHR as one of our top priorities. So, and Owen is he's at the forefront of this and is correct that it is a wide range of different schemes that we're seeing. Someone earlier asked about the history of kickbacks and how long they've been going on. When the department was focused on the drug manufacturers, I think the device manufacturers were not thinking that they were the target of the kickback statute. They have been the subject of a number of kickback cases, and I think now, if the EHR providers. We've had Greg's case in his district that focused specifically on kickbacks that were paid to or by the EHR vendor. That it applies to influence of claims that are submitted to federal healthcare programs, and whether that's in the form of incentives or in the form of claims for drugs or procedures or other things. That's it's within the realm of the anti-kickback statute.
We've talked a little bit in passing here and there about compliance. I think, Owen, you had an interesting observation that in the enforcement actions around EMR, you're seeing that these companies have not done as much or developed as much in terms of compliance and risk mitigation as perhaps more, other types of companies within the healthcare and life sciences sectors. So let's turn a little bit to compliance programs. And we've got a couple questions from the audience, but before we do, I wanted to give Rachel a chance to speak here. Rachel Burke, again, is from Charles River Associates. She's principal, and her expertise is in working with, among other expertises, working with companies on compliance. Just to sort of kick us off, without looking, focusing necessarily on EMR specifically, the compliance environment, now and going forward, can you comment a little bit on sort of where it's at, and in particular on the role that data and data analytics plays in compliance today? For companies of different sizes, it could be large, small, but we've heard a lot about open payments data. We've heard about data that's part of EMR. We've heard about data around speaker honoraria. What data do companies have access to? Are they expected to have access to, and should they be looking at in compliance?
Thanks, Kirsten. Happy to kick this piece off. So the use of data analytics is it's really important. It's become an increased focus in recent years, and regulators are looking at data. Your peers are probably looking at their data, and it's just really important that organizations and certainly compliance functions be looking at the data that you have as well. I would say a common mistake that I've seen in the work that I do, helping companies, sort of sift through issues or work through their investigations, is they simply haven't looked at the data that is readily available. and I see it all the time. And had they simply, looked at what they had, potentially they would have, identified a potential problem earlier or prevented it from becoming a bigger issue. So if I can take a step back for 1 second, you hear a lot today about, a lot of fancy terms: advanced analytics, predictive analytics, artificial intelligence. Those are all excellent tools. But I would say if you could start simple as in the first instance, and just simply understand the data that is available to you, what is available and what's not available, because that's also important as well. And then from what's available, look at what insights can be gleaned from that data. And Kirsten, as you said, it's going to depend, every company is going to have different sets of data, whether it's, it's going to depend on the industry that you're in, the size of the organization, the geographic footprint, of course. But if you can determine, what insights that you can learn from the data, and potentially, for also integrate different data sources. So let's say, for example, you have a whistleblower hotline and tips have increased. But then also you're separately, looking at the payments data, whether it's to certain vendors or to speakers. Is there a correlation that you can draw? Is there a story that can begin to be told from the data sets that you have? And like I said earlier, you want to obviously, of course, identify any potential issues, but also prevent them from becoming, a bigger problem that you could potentially have.
How is data? I'm interested. We have a lot of folks here from DOJ. How does DOJ view compliance programs when it's trying to evaluate a company and a company's potential liability? I know, Charlene, if you want to take this, or Abe or Owen, Ed, any of you.
It plays a large part in my view. We at the end of the day, the reason why, I'll speak for myself, but I know that my colleagues do these programs, is because compliance is an extremely important part of, we want to make sure companies are doing it and doing it the right way. And, with the history of settlements in this department over the years, I think that it sends a message to the industry, and people are paying more and more attention. If you look at the corporate integrity agreements that have come out of not only large settlements, but small settlements, right? I mean, you don't need a Novartis to sort of change the world when it comes to, how speaker programs are going to be, tweaked so that the patients are the ones who are benefiting from, the doctor's professional judgment, and are not, tainted or affected by something that could, in fact, persuade that doctor to do something different than that doctor would otherwise do because of remuneration. I welcome presentations by entities, by companies and their counsel when it comes to compliance. I wish we saw more of them, quite frankly, compliance officers. I'm always willing to listen and understand and get a sense of what is the context and what is the environment under which this company is doing business. I mean, compliance should be after patient safety, and product efficacy should be right there. Are we doing the right thing to the best of our ability? I mean, HHS OIG puts out guidance that is, in our view, very clear. And if there are any questions with respect to certain interpretations of that, they welcome inquiries, and it's an extremely important piece of what we look at in terms of what is this company about, right? I mean, if you have a large company who on paper looks like it's doing the right thing, but in essence, it's not carrying through its mission in terms of, tracking or, enforcement, or when things come to the company's attention, the action or the next steps that are taken are inconsequential, or the underlying message that's being sent to to employees of the company is contrary to what is being represented on paper. I mean, we suss that out, and we get a better understanding of where a company is putting its resources and putting its investment in terms of how are you going to abide by what the law is in this regard. And I will say, as to the smaller entities, med devices, we talked a little bit about it earlier. When all these larger settlements were coming in against big pharma, shortly after that time period, we started seeing more and more resolutions with smaller med device companies. And it's the money that's being invested in compliance. I'd like to see more of it with smaller entities. It's only going to help that company in the long run. So to be operating in the healthcare space, and a small company as you can be, and not have one individual who is providing guidance for HHS rules, regulations, special reports. I mean, it's an important factor in what we analyze. And look, it can cut both ways too, right? So if they are looking at it, but they're doing something that is completely contrary to that, well, that's important too, right? And that comes up, in terms of guidance and other areas that the company is aware of. I can't underscore enough. We're always willing to listen to the programs that are put in place. We encourage companies to have these programs in place. We encourage companies to, really have that compliance officer be separate and distinct, and have a reporting relationships that is, directly to the CEO and not complicated by other factors. And for that compliance officer or somebody specific to that company to have access and review and knowledge of corporate integrity agreements as they have morphed throughout the years in various industries with respect to certain drugs, with respect to certain, compliance as it unfolds. I mean, the CIAs are really, they're the roadmap, and they're really great bright line, guidance, right? You don't have to do it, as to the question earlier, right? Like, is it prohibited if the CIA says with respect to this company, should the rest of the industry be following it? It's a bright line, right? It's something that may be encouraged, is certainly encouraged, may not be required of a particular entity, but it's encouraged. And compliance officers and those in compliance should have knowledge of those and have an understanding of what those provisions are as they apply to their specific industry. And we're always willing to sit and listen to what the company has done. And when something is brought to their attention, and if something has been brought to their attention, what have they, what is the follow-up, prior, not only before what was happening, but more importantly, what did they do to remediate?
One thing I would add is, I totally agree with Charlene. We always listen. We always hear this out. And what we'd really like to see is compliance programs that are empowered, and that I think sort of a corollary of that is come in. I think you're always better off coming in, disclosing to us what happened. There's cooperation credit. You're in such a better position than if we find out, we go to you, or if you are fighting us about things that really aren't what the investigation is about. I mean, a compliance program, I think, should lead to a situation where you come in, describe the facts to us, let's get to a resolution where we can take into account cooperation. And I think that usually happens when you're dealing with a company that has an empowered compliance department, not just a fig leaf.
Kirsten, I'd add to that I think it's extremely critical in that it forms our recommendation for what a resolution should look like. If there is not an empowered compliance person, I actually wrote down the word empowered before Abe said it. If there's not an adequate program to cover the risks relevant to the industry that you're operating in, or if you have years of criminal conduct that are not being caught, the money in these cases, I think we've learned over time, doesn't necessarily have the deterrent effect that we all might want, right? We're talking about speaker programs in May of 2021. We've been doing speaker program cases for decades, and we're still talking about them. So when I look at these cases, it's really about whether or not we can stop bad conduct and make it, release this company into the wild with confidence that's going to do what it needs to do. And if the compliance program was deficient, or in many of my cases, non-existent, then we have to consider that in terms of what the resolution looks like. And often, in addition to a CIA, we might need a criminal resolution so that there's the, downfall if they do not comply with what they need to comply with. We're seeing cases where you have a CIA and the company violates it 1, 2, 3 different times during the course of the 5-year, monitoring. You're seeing cases where they actually might need monitors in place and where you need a bigger teeth should there be non-compliance going forward. I think it's one of the most important issues. And like Charlene and Abe said, it's something I really want to dig into. And I think the companies we've dealt with, the companies that have done the best are the ones that actually had really empowered compliance people that did speak with us and walked us through how they handled things, how they took the problems they had and how they're going to fix them going forward and make sure they're not going to be happening, and how they're going to detect them. I think that's really important. When we see a kickback budget that's enormous and a compliance budget that's tiny, that's a problem.
And to that point, Owen, I'd like to add that you would be surprised how many companies come in when they're negotiating corporate integrity agreements with HHS and are not inclined to have an independent review organization or a monitor in place, specifically in certain healthcare settings, institutional settings, long-term care facilities, because of the cost associated with that. This is about patient care and improving, the lives of individuals in these facilities. And the fact that, it's going to be expensive, and it's going to be expensive for a period of time, and it's going to require mandatory reporting to HHS, and in some cases, the Department of Justice. I have seen such tremendous results and improvements from having monitors in place at these facilities. I can't, there's really no way to characterize it. And so when companies come in and say, this is not something we want to agree to, or this is, a deal breaker in terms of the corporate integrity agreement, these negotiations are going on concurrently. Their negotiations with HHS are certainly, separate and distinct from ours, but it really, it's a window into what is the pattern and practice and the culture of this particular organization when there are certain tools in place that are there to, that's not money that's coming back to the United States or the federal fisc as a resolution. It's to help the company. It's to help the patients and the process at the end of the day, and to ensure compliance with federal law. And it would be, it would be wonderful to see all companies come in and say, look, this is something we're willing to do, or in the spirit of self-disclosure, say, hey, we've identified this particular overpayment, or we've identified this particular pattern of conduct, and here's what we are recommending to do, Department of Justice, thanks for putting, we're putting you on notice of this. And those self-disclosures are becoming more and more of a rare thing. I used to see a lot more of those when I first started doing this. And if to get ahead of it and come to the department and frame the issue is really, it's extremely helpful to the company's, cause.
I've never had a self-disclosure in my career. And I think in only one case have I ever seen a company actually discipline an employee. And some of the conduct we've alleged and some of the conduct that's been agreed to has been egregious criminal conduct. And in only one case have I ever seen an employee disciplined. So you hear a lot of defense counsel talk about tone from the top and culture of compliance. But I would say that what we actually generally see is not consistent with that language.
I just go off in a slightly different direction, but it's related. I think you wanted to talk briefly about private equity companies and their potential exposure. And so private equity companies, as I understand it, are increasingly buying healthcare operations, and they have, as a result, seen themselves more often on the bottom side of the V in cases, and because they have purchase companies that have engaged in fraud and have played a role in that. And one way to avoid ending up on the wrong side of the V if you're a private equity company is when you're about to buy a company and you're doing your due diligence is to make compliance a big part of your due diligence. And if there are compliance issues, to make sure that they get addressed, if not right before you buy the company, certainly right after you buy the company. And then if the company you're buying doesn't have a strong compliance culture or a strong compliance structure, to make sure that you institute one, and so that you avoid the problems going down the road. And the private equity companies that, at least that I'm aware of, that have gotten themselves in trouble are the ones that bought corrupt companies and just let it go, and there was a real focus from the private equity company on making as much money as quickly as possible, either so that they could take the company public or so that they could then sell it to someone else at a profit. And if that's the sort of motivating purpose behind the company, and then there's a huge risk for compliance problems, and the private equity company puts itself at risk, as well as the underlying healthcare entity.
Thanks, Greg. Rachel, I'm going to turn to you on this. I think that's a great segue, Greg. You know, for whether it's in a diligence context or otherwise, are there red flags that, you know, would make sense to be focused on when you're looking at a compliance program, either because you're looking to invest or purchase a company, or internally within the company? What would be red flags that that jump out at you?
Yeah, thanks. So building off what everyone has talked about earlier, and I think Charlene, maybe you mentioned it, there is a ton of guidance out there, a lot of literature and guidance about having an effective compliance program. And I know, Owen, I think it was you that said, oh, you hear a lot about strong tone at the top, et cetera, and you don't really see it necessarily in action, but those are critical factors. And I would say a red flag is if there isn't this sort of culture of compliance that you hear about. Let's say there is no chief compliance officer or someone in some sort of leadership compliance position that is owning this process and, you know, making sure that there really is a focus on compliance and the importance of compliance. That would be a red flag. You know, if there aren't proper policies or procedures, or there isn't training around policies and procedures, that would be another red flag. You know, organizations should certainly consider, and this could be a whole topic for another webinar, but what's happened in the last, 12 to 15 months, with this disruption and working, remotely and virtually, what maybe training didn't occur as it normally would have, or maybe, the platform obviously had to move, virtually. So, I would look out for those types of things as well. And again, I mean, we talked about this earlier, but there needs to be some sort of system in place, whether it's a whistleblower hotline or just an email system, some sort of system in place where, employees are anonymous would be best, but employees aren't reluctant to raise their hand or to say, hey, I observed this, something's going on. And not only that, to make sure an organization is doing something with it. Who is looking at those, potential tips that come in? What happens after that? What's the story to be told there? Is there a control that's put into place, right? Based on the behavior that was observed, and then you could tell the story as someone alluded to earlier. Well, this was happening, but I put something in place, and now it's no longer going to happen. So I've sort of taken care of that. So I would consider those types of issues and look for those types of red flags. Again, we already talked about analytics, but I would say the last thing would be, organizations should also, I'd say a common pitfall when they do set up their compliance programs, it's not static. You don't set it up and then walk away from it. So I would say, I would highly, recommend or advise, organizations and compliance departments to continually look and modify and update those programs, whether by doing employee surveys or risk assessments, or just thinking about what has changed in the last year, whether it's, new systems have been integrated, there was an acquisition somewhere. Constantly, review and update the program that you do have. So that you are facing the latest risks.
Thanks, Rachel. We have about 4 minutes left of the program. I wanted to give my speakers a chance to have one last word. It can be on anything you want to talk about, but if to throw something out there, since we've been wrapping up with a discussion of compliance, on a positive side, if you got a chance to pick one thing that would be a mark of a robust compliance program or a good compliance program, and it doesn't have to be the most important, but something that you would view as an indicator of a good compliance program and a well-functioning program.
I can go first on this one. I definitely, you know, I've seen the range of compliance programs, and obviously the first question is, you know, when we're investigating is if your compliance program is so good, why are we looking at this in the first place? It's a hard place to be in defending your compliance program if you're, you know, already in the room talking about bad conduct. But I will say in one case I was impressed. We were investigating a defendant, and it was a relatively small allegation, but I have to say the defendant was practically giddy in the description of the investigation that they had done, the document review they had done, the witness interviews, they had reprimanded the employee involved in the conduct. They had made changes, sent guidance. There's my dog coming down the stairs to, and I think, and we were able to shut that case down relatively quickly. So, you know, there is benefit to having a robust program, particularly if you can identify the concerns and take action so that when they're in front of us, you already know about the problem and you've already taken care of it, because that's the best way to be in front of us talking about your compliance program. Very quickly though, I would also say, you know, we like to see the actual compliance officer. I have, you know, in some cases you'll see a C-suite full of very impressive individuals, and in, you know, if you want an empowered compliance program, an empowered compliance officer, we want somebody that's equally impressive, and, you know, in the best compliance programs, that's what you see, and in the less robust compliance programs, sometimes there's a concern that it's not the same gravitas when the compliance officer is speaking.
I don't have much specific to add to what Ed said, but I do want to echo that I had a situation where I had a case, we settled with this company. I didn't think its compliance was very good in the first iteration. A couple of years later, there was a one-off incident with a sales rep providing a bribe to one doctor, and the doctor demanding the bribe. And the compliance department at the company seemed to really handle it. We did what was a very brief investigation, and the way that they described it was exactly what it was. It really was a one-off, and that was the end of the case. And, you know, it's sort of along the lines of what Owen said, that's pretty rare, but I think that's exactly the outcome that any company would want, right? They come forward, they describe to us what happens. It's very, you know, as far as I can tell, it's really capped off. Maybe they're laughing on this Zoom without me knowing, but that's how it appeared.
Greg, you're a whistleblower lawyer now. Do you care about compliance, or is it all just about proving liability? Or are they related?
I have to say, I think from our perspective, compliance is not a big part of it. Sure, I mean, we're frequently not going to know that much about the compliance program. But to the extent that we can add that as an allegation that the company, that higher ups in the company were aware of the conduct, that's certainly going to make it, I hope, more attractive to DOJ when we present the case.
We've seen actually an increase in compliance officers or those working in the compliance department as whistleblowers. And it's interesting to see how that plays out in terms of, you know, privilege issues, which, you know, I think Ed's example and Abe's examples are stellar, because, you know, companies are just afraid to come in and disclose because they are concerned that, you know, peeling back the layers of the onion, we're going to find something, we're going to keep investigating, it's going to tie up the company for years. And why I love Ed and Abe's examples are because when companies, in my view, do the right thing and disclose conduct and disclose the internal investigation, and I understand there are privilege issues that have to be dealt with, because many times those investigations are done by lawyers hired by the company or internal counsel, right? Sometimes at the direction of compliance officers, sometimes at the direction of the CEO. But when companies are willing to share that information, and if it is as Ed and Abe have described in their examples, I mean, the right result will be, and it more often than not. And again, it's indicative of a company's corporate culture and, you know, what's happening at the top, and, you know, how that whether or not that's a pervasive pattern, it really does make a difference in terms of disclosure and the department's response.
Thanks very much, Owen. We are at 2:01, but I'll give you the last remark. If you want.
Nothing additional from what my colleagues said. I fully agree. I've had 1 or 2 cases where midstream they've made some compliance overhauls that have warmed my heart, and it was to their benefit. And you know, that's all we're really trying to do. So I echo what my colleagues have said, and thank you, Ropes and Greg, for inviting me with my colleagues here. And it's nice to speak with you all.
Thank you very much. And I know we're at 2:02, so I want to make sure everybody can drop off and get back to their day. I just want to say just a huge thank you to all the panelists for participating and for the candid discussion. Thank you to the audience for the excellent questions. And I hope everybody has a great afternoon.
Thank you.
Thank you.
Thank you.
Thank you.